Good afternoon, ladies and gentlemen. Thank you so much for joining us today, and welcome to this webinar. Today, we want to talk about competition law, and in particular, we want to discuss some of the latest developments in competition law. One of our areas of practice is competition law, and we have a newsletter. In case you're not subscribed to our newsletter, I'm going to drop the link on the chat box, and you can subscribe to our newsletter. And for the in the recent past, in I think close to 3 months now, 3 to 4 months now, we have been writing on competition law as our thematic area. So you can find that on our newsletters. If you go to the link, you can be able to access that, as well as on our LinkedIn. As I said, we're going to cover recent updates and developments in competition law. And our speaker today is Annette Njoki. She is a lawyer here at Njogu and Associates Advocates. I'm going to allow her to introduce herself further as she takes us through today's webinar.
Thank you so much, Njoki, for that good introduction and the firm's introduction. So without much further ado, I will just share my slides and we can dive into it. This is our outline. First, we look at the aim of the webinar. Why this webinar? Secondly, we will look at general overview of the regulatory framework. Third, we will look at developments in the competition law. Here we will look at case law, but we know case law forms part of the precedents in any field. We'll also look at the Competition Amendment Bill 2024, and then we look at best practices, and then we can conclude. The aim of the webinar has 3 fronts. First, to delve into key cases recently decided by the Competition Authority. That is first of all our very main aim. And in these cases, we will learn what is the mind of the Competition Authority once they look at competition cases. We'll also learn for us in various industries and on this call today, some of the decided cases, how can we apply the judgments or the determinations in our various fields. It can be in the financial sector, it can be in the manufacturing industry. We look at all these, the mergers, acquisitions, joint ventures, all models of a business that it can be, a sole proprietorship, competition cuts across everything. We'll also look at how, as participants, how we gain valuable insights from this. And we look at how they shape the various competitive practices across sectors. And lastly, we'll close by looking at the overview of emerging trends in the competition space. And looking at all these 3 things, let's have these 3 aims at the back of our minds. And at the end of the webinar, we will come to answer these questions. Have we looked at these decided cases? Have we gained any valuable insights? And lastly, have we known the emerging trends, and how can us as participants in the call, we'll have a time for us to even engage and just pick each other's brains and understand how we can also shape the emerging trends and considerations for our various industries. Great. On to our first bit of the webinar, the general overview, the legal framework in Kenya. The Competition Act, Cap 504, forms the legal framework of competition law in Kenya. And this act, its main objective is to promote and protect effective competition in the market. That's its main role, that's its main purpose. That's why it was enacted. And how does it do this? It prevents unfair competition and misleading markets conduct throughout the country. And I was looking at it for instance, let's have an imagery of the Competition Act. It is one that is enforced to have checks and balances. It's the one that keeps the market, the business sector, the various companies, the various industries in the country in checks and balances. And for it to have, it is sort of like a judge. It's the one that listens to disputes. It ensures that the people it acts as a fair and impartial person when you look at competition law. So that is its main ambit, and it is a very, very comprehensive. By offering better terms Prices, quality, and choices. Keep that at the back of your mind. For any business, first, you want your business to be the best, right? To offer the best quality of things, to offer better terms so that people can come to you, so that people can be attracted to your company, so that people can be attracted to your market, so that they can be attracted to your product in general. If it's for a financial institution, we have so many. Currently, we have 58 banks that are registered with the Central Bank of Kenya, and all of them, once you look at their advertisements, they all have a selling point to it. Before even as we continue, there has been a recent development, or rather a recent case a recent buzz in the social media, where we have had this lady who is selling things 3 times less than the retailers and the wholesalers. Yeah, and it has caused a great uproar with a lot of traders. They're saying, if I sell my plate at this price, and she comes and sells, if I sell my plate at 500, she's selling the plate at 50 shillings. And people will be attracted to her. So what is the role of the competition authority when it comes to that? Does it have a role? Is the act silent? We'll be picking each other's brains when we look at all that. We have a company in this case, a company that sells soda. If you think about soda, what comes to your mind? Coca-Cola, right? So we have we have Pepsi, we have club soda, but what is the market dominance of all the three? And what's the place of the Competition Act? Think about that oil that you apply. We have so many oil products. We have so many skincare things. We have Nivea. We have a lot of the Roche-Posay. We have CeraVe. We have a lot of these skincare. But what is their market ratio? We will have a term that will feature when you talk about competition law. That is the dominant position. When we talk about dominant position, what do we mean? It is for a company or your business to have a significant market power, right? Think about Coca-Cola. It's the best example we can use. Think about Safaricom. These are very, very triggering companies that we can think about when we talk about competition, where it allowing it to operate independently of competitors, customers, suppliers, without losing profitability. Even if you don't take that soda, and let's say if you all don't take that soda, let's say your company doesn't take that soda, there's someone else somewhere in the country who will take, and if you think about it, you will go for that product because that's the one that you know, their dominance is great. Here, a company or an organization or a business may be considered to hold a dominant position if it has a market share of at least 50% in the relevant market. And we can all agree that Coca-Cola has 50%. If you're in objection, you can type on the chat box. You can even school us and tell us which other company, because personally, I just know Coca-Cola has 50% when we talk about beverages, soft drinks, right? Great. So when we talk about competition, we have looked at the term competition, we have looked at the term dominant position, and also when we look at the act in whole, it operates in Kenya. However, in the act, it provides extraterritorial operations of the act. Where else can the Competition Act apply? The act shall apply to conduct businesses outside Kenya, where you're a citizen of Kenya or a person ordinarily resident in Kenya. Secondly, a body corporation, where we are going to see most of these joint ventures and mergers that we are going to look at. Most of these consortiums, most of these firms that come together, most of them, maybe they're not domiciled in Kenya, they're not incorporated in Kenya. However, how do they succeed in making a merger and acquisition? How does it become a joint venture? And how does the Competition Act itself regulate that field? Thirdly, any person in relation to the supply of acquisition of goods and services by that person into or within Kenya. And lastly, any person in relation to the acquisition of shares or other assets outside Kenya resulting to the change, this is very key, to the change of control over business, parts of a business, or an asset of a business in Kenya. And we look at various case laws where before the competition authority allows, for example, a merger, allows for a joint venture, there are things that it considers. How is a competitive scale in the market? And what are its pros? What are its cons? If we weigh them, which is more? And as we proceed, we can also look at most of our retail stores. I remember there was a famous case, there was a case that was determined a few months ago by Carrefour and Orchids, the beverage industry, where they have, for Carrefour, they have a very unique model of how they source out their products and the competitive factor of that retail store as opposed to other stores. If you have subscribed to our newsletter, we have delved much into that case. So great. So the Competition Authority of Kenya, it is established under Section 7 of the Act. And some of its key functions include, but not limited to, it promotes and enhances the compliance of the Act as a whole in general. Secondly, it makes available to consumers information and guidelines relating to the obligation of persons under the Act. What is, as a consumer, what are your rights under the Act? What are your obligations under the Act? If you have a complaint, how should they go about it? Thirdly, to receive, this is such a key function of the authority, to receive and investigate complaints from legal or natural persons, that's a company, and consumer bodies. And we will see how this function is so effective with the Competition Authority of Kenya. Fourth, it investigates, including the entry into and exit from markets in the economy. If we look at the recent entry of JP Morgan Chase Bank, the Competition Authority produced a very comprehensive document explaining its acceptance into the entry in the Kenyan market, which we will share later on. Fourthly, to participate in deliberations and proceedings of government commissions, regulatory authorities, and other bodies in relation to competition and consumer welfare. They advise the government on matters relating to competition and consumer welfare. If you think about competition, you cannot lack to think about the Competition Authority, where it has a lot of functions. When we talk about the Competition Authority, we can't lack to talk about the Competition Tribunal, which is also established in the Act under Section 71. Some of its functions include, some of the functions of the tribunal is to hear and determine cases brought by the authority. Great. So who can bring a claim to the tribunal? Any person who, by a determination made by the authority under this Act, first, is directed to discontinue or not to repeat any trade practices. Any person who, by a determination by the authority under the Act, is directed can appeal to the tribunal. Any person who is issued with a stop or desist order to repeat or not to repeat any trade practices. Finally, any person who is permitted to continue or repeat a trade practices subject to conditions prescribed by the order. Any person who is directed to take certain steps to assist existing or potential suppliers or customers adversely affected by and prohibited trade practices. Any person who is ordered to pay a pecuniary penalty or fine. And lastly, any person who is aggrieved by a stop or desist order or any other interim order of the authority. And when we look at this, for the authority, it has the mandate, or it has the power to issue a cease and desist order to a particular trader, to a particular corporation, a legal person or a natural person, to if it looks and says, First, you're affecting the products. You're affecting the market of this particular product. Secondly, it is causing a public interest uproar. Maybe you're rendering many people redundant. You're rendering many people unemployed because of your vehicle. We will look at the steps that the authority uses when it looks at any competition case. Great. So to the greatest part of the webinar, that was just an introduction framework for us to have for us to have just a little touch up of what we talk about when we say about competition law. We have the competition authority and we also have the tribunal. Great. On to our first case law that we will look. The case law that we look at, there are case laws that were just one that was decided yesterday, that we look at it. We'll also look at the ones decided in September and August. That is Q3. We look at the Q3 case laws. First, what happens when some clauses in an agreement are misleading? You walk into a bank, you read and understand, you're like, oh yes, I read and understand that mortgage agreement with your bank, with your financial, you read, you understand everything. And then in the middle of the contract, you realize what was written is actually it's not what is being practiced. What do? And how did they sell that product to you? Because a financial service is a product in the market. So what do? The Competition Authority of Kenya, in its decision regarding misleading representation and unconscionable conduct by Mogo Auto Limited. So the brief facts of this case are, this company is part of a group, an 11 group that is incorporated in Kenya. And the product that they sell is car loans and logbooks. They're in that industry for motorcycles and motorbikes, the bodabodas. That is their main product that they sell. So for consumers in this sense, were able to lodge a complaint to the Competition Authority. This is their claim. First, the first person said they took a facility with the financial. When they took the facility with the financial, the terms were, we'll maintain this contract under the exchange rates of 118 Kenyan shillings is to $1. And the term dollar when we talk about the dollar currency here, we're just referring to the exchange rate so that we can look at how much money you will end up paying. However, when you pay up your money will be calculated in the Kenyan currency, not in the dollar. That was what was presented, Party A. And the first complainant said, that's great. However, if you're giving me this facility, it will be at a 2.6% on a flat interest. Just look at those facts that are being presented to the complainant. A 2.6% flat interest, and we'll be calculating your dues in Kenyan shillings. However, some few months down the line, once the contract was solidified and they started and he got the facility and continued doing as per the terms of the contract, complainant went realized that they had changed. They had changed the 2.6% from the flat interest to reducing balance. It is contrary to what the contract was saying. And it will be calculated in USD and not Kenyan shillings. How comes? So complainant 2 comes, and complainant 2 says they took a facility with the same financial, and with this financial, the balance was computed in USD. However, when they sell out in the market, in their advertisements, they are computing it in Kenyan shillings, and they're not making the consumer aware that we'll be computing it into dollars. Party 3 comes. When Party 3 comes, they say they wanted to purchase a motor vehicle and they got the facility and they were able to offset this this vehicle with the facility they got from the financial. So they were supposed to pay back the financial with 60 months installments. However, this will be calculated in Kenyan shillings. But Party C and D say it has now been calculated in dollars. What am I supposed to do? Why did the financial will call Party Y here? When they were selling it to me, they were selling it in, they told us that they will be selling it in Kenyan shillings. Why are they selling it in dollars now? Great. So that's where the misrepresentation comes in, the misleading. So the Competition Authority looked at the case, investigated the case, and once it was determining the facts of this case, it was looking at it in 3 bits. First, it was looking at the mitigating factors in it. When you talk about mitigating factors, is this a first-time offender? When you talk about what is the cooperation and what is this, or have they done any self-reporting unit? And also they looked at the aggravating factors include where you're a repeated offender in this sense. And this was their determination. The financing institution was found liable and they were ordered to pay a penalty of 10,851,473. Secondly, they were ordered to amicably resolve all the pending complaints and lodged at the authority. So they were a repeated offender. Resolve any future complaints within the stipulated timelines and refrain from engaging in similar conduct in future. It is something they have been doing, misrepresenting. And lastly, employees to undergo consumer compliance training. Great. That was the first case. Let's look at the second case. Great. This is a case that was just that was released yesterday by the Competition Authority of Kenya. Its decision on the proposed acquisition of the entire issued share capital of the National Bank of Kenya Limited by the Access Bank PLC. Great. I think it was put in public some few months ago on the acquisition of the National Bank of Kenya. So how did this go about? Some brief facts of this acquisition and how the Competition Authority was able to come to a conclusion to give it a go-ahead. So when we look at the acquisition of the National Bank of Kenya, firstly, Access is a Nigerian bank and it has its dominance in Kenya. It has 23 branches situated in 12 counties. The National Bank of Kenya is a subsidiary of the Kenya Commercial Bank, KCB, as we all know it. Access Bank is acquiring the National Bank of Kenya. However, under a condition by the Competition Authority of Kenya, that on the first 1 year, Access Bank will be able to transit 80% of the employees of the National Bank of Kenya into the new acquisition that they'll be having now, Access Bank and the National Bank of Kenya. It will be able to transition 80% of its employees there. Now, how did the Commercial Bank of Kenya get to a conclusion and say, this acquisition is great for our people, or this acquisition is actually, it won't cause any competition in the market? There's some factors that they looked at. First, what is the product being sold here? Financial services, correct. Secondly, what is the geographical landscape that this bank wants to look at? What is its geographical market? It's nationally, that's in the whole country of Kenya. Thirdly, what is the post-acquisition effect? When you look at the post-acquisition effect, it is once the acquisition has happened, what are the effects that will happen in the market? When you look at the market, it's 100%, right? Let's have, at the back of our minds, let's look at a whole 100% of a market. A market represents 100%. So how much shares does it have in this 100%? And they were able to see when Access Bank is to acquire the National Bank, in itself, Access has 0.2% in the financial sector market. If it acquires the National Bank of Kenya, it will transition from 0.2% to 1.9%. Does it cause any competitive factor in the industry? We have 58 banks registered. I think as per December 2023 last year, we had 58 banks that were registered in Kenya. Will the 1.9% affect any will it cause any competitiveness? No, it won't. It won't affect any, it won't cause any negative effect. Lastly, what is the role of the public here? Public interest. Yeah, some people will be rendered jobless with this acquisition, because you hear they will be having 8% of the employees. What happens to the 20%? So there's a public interest factor that it looked at. When it looked at this, 20% of it, it said you will be able to retain 80% of the National Bank. Yes, 80% of the National Bank of Kenya employees. However, the people who you terminate the contracts, you have to compensate them, for us to say that the proposed acquisition is right. And that's how the Competition Authority was able to rule through it. And we will see in all its decisions, it looks at them in 4 bits. If you have a complaint when it comes to consumer protection or competitiveness in the market, the Competition Authority looks at it in 4 bits. First, what is the product? What is the product market? What's the product market that you're trying to sell? Secondly, what's the geographical market you're trying to aim at? And thirdly, what is the post-merger? What's the post-acquisition or something like that? And lastly, what is the public interest in this case? And when we talk about public interest, we talk about how will it affect employment? How will it affect SMEs, small and medium enterprises? How will it affect other companies to even compete internationally? These are some of the questions that the Competition Authority looks at when it determines these acquisitions, when it determines these mergers, when it looks at that competition complaint that you will lodge to them, either via phone, via email. They look at all those 4 bits. Great. Another case development that has happened in just the recent months, the proposed acquisition of 51% shareholding of Monarch Insurance Company, which I know most of us, or 3/4 of us, are aware about the Monarch Insurance Company, by a consortium of 3 firms. Great. So these 3 firms, when we talk about a consortium, it's a merger of 3 firms towards a particular goal. Great. How did Monarch, what is the aim of this consortium in the financial services sector? And they want to acquire 51% of Monarch Insurance Company, which we all know it's an insurance company that offers both general and life insurances. Great. So the merger and acquisition, so the Competition Authority will sit back and ask itself, how will this acquisition affect the market? If we agree and give a green light to this consortium acquiring 51% of Monarch, how will it affect the public? That is part of its mandate. It's going to investigate and look at the pros and the cons in any merger, in any competitiveness, in any industry that we are saying we have a dominant position. It will look at both the pros and the cons. So it's not and asked, correct. We have a consortium, right? And this consortium wants to acquire Monarch Insurance. All right, that's fine. Great. So it wants to acquire 51%. That's a great percentage. How will it affect the insurance industry? Because we have roughly, I think 23 insurance, 39, if I'm not wrong, 39 insurance service providers. So what is the main aim of this acquisition? It's for business growth. All right, let's get to the drawing board. What is the product being sold? Insurance services, correct. Secondly, what is the geographical market? The geographical market is it's in the nationwide, correct. That's fine. Thirdly, what is the post-acquisition effect? When you look at the post-acquisition effect, how will it affect that industry in itself? How will it affect the insurance industry? When you look at the insurance industry, we have close to like 58 licensed service providers. However, it is distributed into two. We have the life insurance and the non-life insurance, which is the general insurance. 39 of these companies provide life insurance, and the rest of them provide non-life insurance. Great. So when this consortium acquire Monarch, what does Monarch do? Monarch provides life insurances. So we are looking at 39%. What will be the 39 of this of the insurance service providers? So what effect will this acquisition cause to these 39 insurance services? Remember, the competition authority here, it is a judge to act on fairness and that everyone gets a piece of the cake and everyone gets a piece of the pie in this sense. So it looked at it and it saw that it will only have a 0.05% to the whole share, which is 100%. So if we are able to give a green light to this, it will be able to have 0.05% in it. And why will it give it a green light? If we talk about public interest, it doesn't affect any employment, it does not cause any impact to SMEs, and it does not cause any impact to companies not to compete internationally. And the determination of the authority was, the authority approved the proposed acquisition of the 51% of the issued shares of capital of Monarch Insurance Company Limited by the three consortiums unconditionally. Great. So even as we move on to cases, we will see one factor with the competition authority. It has to fit in the 4 bits. First, what is the product? Secondly, what is its geographical market? Third, what is the post effect? And lastly, what is the public interest in this case? There's also another case here, the proposed establishment of a joint venture between Astel Trading Company and Kingsbourne Assets Limited. This was a recent decided case in the month of October. And not a case, it was a dissemination by the Competition Authority of Kenya. And you may ask, what is a joint venture in this sense? A joint venture is an integration of operations by two or more separate firms to establish a new enterprise. And in this enterprise, they act as a parent firm to this new joint venture, where we call it a joint venture vehicle. However, it is independent on its own to perform various operations as on its own without the reliance of the parent firms. However, the parent firms invest into this vehicle. So for this joint venture, the companies are in the paper manufacturing, industry, the importation of paper and the products that are in line with the creating of the paper in itself. So when this case came to the Competition Authority, because you have to lodge a request to the Competition Authority, they were able to look at the 4 bits, as I mentioned. What is the product in this case? The product here is the photocopy paper that we seek to. This is our business. We're in the photocopy industry. All right. So why are you doing a joint venture? And first, one of these companies, that's the Kingsbourne Assets Limited, is actually not incorporated in Kenya. It's in the British Island. So how will this work? They looked at so where will you be domiciled? They said we will mainly be domiciled in Kenya. So that's the nation at large. That's the geographical market. So what is the post-merger effect, or what's the post-acquisition effect, or what's the post-joint venture effect? So it said that it holds 15% of the market of printing. So among all other companies that form 100% of this market, they have 15% of this, stating that 85% of the remaining industry are for other service providers. For them, they just hold 15%. Is that unfair? No, it is not unfair. So at the end of it, the authority approved the proposed establishment of a joint venture between Amstel Trading Company and Kingsbourne Assets Limited unconditionally. Great. So when you look at all these cases, the Competition Authority has it in four folds. It has to look at one, the product market, the geographical market, and thirdly, it will look at what is the post effect, and lastly, what is the public interest. As we have looked at the Competitions Act as a whole, Cap 504, there's an amendment bill 2024 that has been tabled. And what does this bill seek to achieve? Or what's the aim of this bill? Firstly, the bill proposes to include digital activities in the interpretation of expression and assessment of dominant position. Let's just delve into an example here. We are all moving into the digital platform. Many of these service providers are now moving into the digital space. There's quite a lot of competition when it comes to the digital platform. Has the Act covered the digital platform? And we talk about competition in the digital platform, we can look at, for an example, like an app, Instagram. If we look at Instagram, most of these people have their own pages, maybe online stores. The person who has an online store and the person with a physical shop, as well as an online store, their margins don't look the same in this sense. The online store has no rent. The online store, they may be the sole trader, so they have no salaries that they need to pay. If it's salary, it's just them, the sole trader. Thirdly, they do not incur any license fee or charge. But when you look at the physical store trader, first, they have to pay license. Secondly, they have to pay rent. They have to pay employees if they have an employee in that sense. The competition is not the same. And how much is your dominance? You may be in the online field, but we're in the same industry, we're in the same insurance industry. But your dominance may be so rampant, more than me, who am in the physical, who own a physical store. So the Act is silent when you talk about the digital activities. And this new amendment bill seeks to include digital activities in the interpretation when you talk about dominant position, the market power. You earn 50%, you actually have power, right? So that is one of the proposed amendments. Secondly, the second amendment is to increase the functions of the authority to recognize consumer bodies duly registered under the appropriate national laws as the proper bodies in their areas of operation, and also to represent consumers before the authority, as well as carry out inquiries, studies, and research into matters relating to competition and the protection of the interest of consumers. That is also a second amendment that it seeks to pass. Also, the bill proposes to amend the regulation of intermediaries that are considered to be in a dominant position. When there are so many cases that have been lodged when we talk about Safaricom. There's so many. I remember just a few months ago when Starlink, the case about Safaricom and Starlink was so rampant. And this I will refer to our newsletter where we have really delved much deep into that case when we talk about Safaricom and Starlink. And the recent case that was lodged about Coca-Cola being a dominant seller of soft beverages. The bill proposes to amend the regulations where if we have intermediaries that are considered to be in a dominant position. Also, the bill seeks to add mergers of institutions that have undergone privatization. And lastly, the bill seeks to provide for the role of public in mergers of undertakings. Great, like that, and the undertaking by for a very good example is the acquisition of the National Bank of Kenya. In the acquisition of National Bank of Kenya, remember it's a subsidiary to Kenya Commercial Bank. However, it had two undertakings. First, it had the KCB Asset Management, and secondly, it had Sorry. And secondly, it also had another undertaking where it was called the National Bank of Kenya Bank Assurance Intermediary, where it was when it was being acquired, it was acquired together with it. However, the Kenya Commercial Bank Asset Management was not acquired, it was returned back to KCB. So the bill seeks to further provide what's the role of the public when it comes to the mergers of undertakings in this case. Great. So what are the best practices for organizations? What are the best practices of various industries? What are the best practices for various sectors? What are the best practices for you as a sole provider, a sole trade? What are the best practices? First, transparent and inclusive merger practices. Given the proposed requirements for public input on mergers, companies should adopt a transparent approach. Put everything out there. The authority actually has a mandate to inform the people when we have a merger or when we have an acquisition. I remember when the acquisition for the National Bank of Kenya, which is a subsidiary of KCB, the public was let know in good time. Secondly, fair pricing and unbundling of services with stricter regulations on the digital and tech sectors. Just as I said, someone with an online store, someone with a physical store. Are they on the same platform? Are they all trading in the right way? What does the Act actually say in line with that? Great. Responsive approach to regulatory changes. The competition law, we can never finish when we talk about competition law, because if you think about competition law, we look at e-commerce, we will look at people who is so-called brokers. They're also in the competition field. When we look at competition, we look at what antitrust. So the Competition Authority of Kenya keeps on releasing new bits and pieces in the competition law. Because even if you just ask someone randomly, did you know that antitrust forms part of competition law? When you buy something online, would you rather buy something in a physical store, or you would rather buy on in an online store? Lastly, digital market fairness and platform neutrality. For tech firms, promoting fair access to their platforms for third-party services and competitors is crucial. Avoiding restrictions on third-party services and adhering to platform-neutral policies. That is some of the best practices that can be incorporated. And what's our conclusion today? Our conclusion in today's webinar, it has provided a snapshot of the evolving landscape of the competition law. It keeps evolving. However, these recent developments have various implications to various sectors. As discussed, the public are being involved in the merger, are now being proposed to be involved in the mergers to new regulatory approaches. The digital market, the digital platform. And for us, we have no obligation but to take part in the policy drafting, to take part in the contract in the contract drafting of these various sectors when we talk about the digital platforms and etc. So while these are just a few of the many advancements taking shape, it's clear that our market condition and technologies evolve, so too are the legal frameworks guiding them. And ladies and gentlemen, with that said, those are some of the few recent developments under the competition law in Kenya as per October. Thank you so much. Do we have any questions on the chat box? Anyone with a question, a suggestion, or a comment? If you have anyone, you can also share in some inputs on what I've just presented. I remember on the registration link, we were able to see one of the questions. How does one lodge a request with the Competition Authority? First and foremost, you have access to the Competition Authority. You can either call, that's the first thing. You can either write an email, or you can be able to just fill in the form on their platform on a consumer complaint, and they'll be able to review it and offer remedies to it. Any questions in line with competition law at large, or any question that you may have, a comment? Thank you, Ruth. Thank you for the presentation. It was clear. Asante sana. Thank you so much, Ed. Insightful presentation. Asante. Any more questions on the platform? Going one. Thank you, Peter. Great presentation. Asante. Going once. Going twice. Going thrice. Thank you so much, ladies and gentlemen, for joining in today's webinar. We'll be having more webinars, and we will be sure to share this link with you, share the slides with you, and for our future webinars. Asante sana, and have a good evening.